While it's difficult to predict all of the impending lawsuits from the Baltimore disaster, lawyers say they have an idea of what's to come. And amazingly enough, regulations dating back to when most commercial ships were still powered by sails could come in play.
And she sits over in Aquatic Park right now.
Attorney John Hilsman has spent a legal lifetime learning about ships, boats, and nearly anything that floats. And he's seen his fair share of disasters, including representing Bay Area fishermen in the Costco-Busan oil spill on San Francisco Bay. But he says charting a legal course often begins with untangling an obscure maritime law that stretches back more than a century.
The Shipowners Limitation Liability Act literally dates from Gothic, medieval concepts, but it was enacted in the United States in 1851, the same month that Moby Dick was first published.
That's right, that Moby Dick. And like the famous novel, it is a twisted tale. Hilsman says the law was originally intended to encourage investment in American clipper ships, shielding owners from maritime disasters. In most cases, it limits liability to the value of the vessel and its freight. For the payout, the owners are allowed to wrap all of the claims against them into a single case and ship it to a special maritime court where it's heard by a judge, but no jury.
Where the court says, you claimants have until, they'll pick a date, July 1st, 2024, to file any claims you may have against the owners of the Dolly, this vessel, in my courtroom. If you don't make that deadline, you can potentially lose your claim forever.
In the infamous sinking of the Titanic, all that was left were the lifeboats. And even after negotiations, the reported settlement averaged just $430 for each of the 1,500 victims. And while the recent disasters like the deadly Conception fire off Santa Barbara have sparked calls to rework that law, it still shapes many maritime cases today. But Hilsman says there are other strategies left in incidents like the Baltimore disaster.
The plaintiffs in that situation will be looking for other people to sue. They'll probably try to go after the Coast Guard for certifying the vessel as safe. They may well go after the state seeking defects in the bridge design.
And like the massive Exxon Valdez oil spill, lawyers might try to prove the owners knew about the problems with their ship or its crew members ahead of time. But with deaths involved, Hilsman believes many companies and their insurers want to avoid the lasting stigma of a court fight and will choose to negotiate with victims' families instead.
Then I think very quickly there'll be negotiations with the families to get them out of the picture as quickly as possible.
But the broader damages are expected to be massive, and with estimates being floated in the billions, there's a chance that a century and a half of maritime legal history could once again repeat itself.
Critics also point to one other political irony. While the Liability Act was meant to boost American shipping, just a small percentage of modern commercial vessels are actually U.S. owned, meaning the protections would more often benefit foreign companies.